Welcome back to module 4, and in this module we are going to cover where does the client data go when it's been put into AI to be summarized or for key points to be taken from it, or even in this case, based on our scenario, for legal research. All right, section 1. Let's understand what the actual data problem is. All right, before writing a single governance procedure, you've got Helsted and Co. And just remember that Helsted and Co. is a law firm, a fictional law firm for this scenario, and they must understand exactly what data moves through each AI system that they have rolled out within their firm. This is from fee earners keyboards to models, interface servers, and back. Yeah, from the fee earner, the information from the model's front end, it goes to wherever this model is hosted and then goes back to the fee earner. Most law firms have had AI related breaches before, but didn't know that this map existed. And this is what this actual module 4 is going to build. Currently, Helsted and Co. They are at, or they have completed phases from 0 to 2. They've got a risk register, a live risk register. Now, when it comes to the data processing agreement, one is required. When it comes to the data processing status, there is none. And then finally, you've got the client disclosure, making the clients aware whenever they have been sent information that's been generated by AI. Now, the three AI data flows at Helsted and Co. are mapped below. Let's take a look at it. They've got their commercial LLM. In this scenario, it's going to be Anthropic's Claude. And when it comes to the input of data, clients' instructions, matter facts, fee earners, prompts may include personal data, i.e. client names, addresses, financial positions, and legally privileged matter content. Now, when it comes to the inference location, when it comes to Anthropic, Anthropic is based in the US. The API goes to US servers. Data transmitted across international boundaries. It leaves the UK to go to the US. There is no transfer mechanism in place. Now, when it comes back down to the output from the US back to the UK, back to the fee earner who inputted the data, AI generated draft text, research summary, or correspondence returned to the fee earner in Word or email. There is no disclosure to the client. This is their current mapping. The fee earner inputs some information, it leaves the UK via API to the US servers, it gets processed, and then gets sent back to the UK with its output, whether that's drafted text, research summary, and so on. Next, you've got the contract renewal tool, which currently for Helsted and Co, the vendor is unknown. Now, where the input is that the client's contracts, due diligence documents contain personal data, i.e. directors, shareholders, employees, and commercially sensitive transaction terms. Now, when it comes to the location, the vendor's unknown, the location is unknown. So the vendor's not identified, the data location, retention policy, and training use terms are all unconfirmed. This is an active GDPR breach. And then you get the output back, which is contract clause analysis used in M&A due diligence. Corporate team acts on output without formal verification. This whole contract renewal mapping tool that we're showing that Helsted and Co is mapped to is not only a breach to UK GDPR, but it's also a breach to the ISO IEC 24001 23 edition standards. And then finally, you've got their word macro prompts. All right, this is internally. The fee earner's prompts may include client matter content depending on how the fee earner uses the macro. Now, when it comes to the location, this is unclear. Macro may call external API endpoints. Fee earners do not know if the data leaves the device. This requires investigation. Then the output is drafting assistant text. No version control on the prompt instructions. No control on what instructions were in use when a given output was produced. Now let's just make something clear here. When it comes to the UK GDPR Article 46, now under the UK GDPR Article 46, a controller may only transfer personal data to a third country, such as the United States where appropriate safeguards are already in place. The approved mechanisms under the UK GDPR are A, the UK International Data Transfer Agreement, B, the UK Addendum to the EU Standard Contractual Clause, or C, an adequacy regulation covering the destination country. The United States do not have a UK adequacy regulation in force as of 2026. So when Halstead & Co. submits client personal data to Anthropic's API, it is executing an international transfer with no documented safeguard in place. This is a risk. And this module is what's going to help close that risk. Let's look at data governance, knowing what enters the AI and what comes back. Now, when it comes to the ISO IEC 42001, clause 8.3, which requires the organization to ensure appropriate measures are in place for data used in AI systems, that is covering acquisitions, processing, storage, and disposal. Now, at Halstead & Co., this means a documented procedure that every fee earner using a tool, an AI tool, should follow. All right, let's look at the areas of this documentation. All right, building an SOP AI management system document. And this requires 6 provisions. All right, provision 1. Now, provision 1 addresses clause 8.3 and the UK GDPR, article 5, data minimization. What we're doing here is we're defining the permissible data categories for each AI system. SOP shall specify per AI system which categories of data fee earners are permitted to submit. All right, now fee earners may submit anonymous matter facts, general legal questions, and draft text for style improvement. Fee earners shall not submit client names, addresses, financial information, or any data that would identify an individual until a signed data processing agreement and a valid UK Article 46 transfer mechanism is in place. Now, fee earners shall not use the word macro for any inputs containing identical client data until the inference location of the macro is confirmed as either local or covered by an executed data processing agreement. Data minimization is not a nice to have. It is a UK GDPR Article 5 requirement. All right, let's look at the second one. Now, the second one falls under, again, clause 8.3. Also, the UK GDPR Article 28, which falls under data processing agreements. Now, establish a DPA tracking register is part of the SOP AI management system document. Now, the SOP shall include or reference a data processing agreement tracking register, a simple table recording for each AI system using cloud inference, the vendor name, the data processing agreement reference number, execution date, transfer mechanism type, and what that is basically the UK IDTA or the UK addendum to SCC, and review data. No personal data shall be submitted to any system where the data processing agreement status field is blanked or marked as not executed. Now, the AI management system program lead shall update this register whenever a data processing agreement is signed and shall notify the AI risk owner. In this case, in terms of the scenario, that is Priya, and this will be done within 24 hours. The tracking register is assigned a document ID and shall be stored in the AI management system document control register alongside the SOP AI management system document as well. Let's look at number 3. Now, number 3 falls under clause 8.3 and the UK GDPR Article 5, E, which is storage limitation. Now, what we're doing here is defining data retention periods for all AI inputs and AI generated outputs. Under the UK GDPR Article 5, Section E, requires that personal data is kept no longer than necessary for the purpose for which it was produced. For AI systems, this creates two distinct retention questions. The first one is, how long does the vendor retain information or data rather that has been submitted via its API? This must be documented per system in the Reg AI management system document, obtained from the vendor's data processing terms. Now, second is, how long does the firm retain AI generated outputs? The SOP document shall specify AI generated drafts that are incorporated into client files shall follow the firm's standard matter file retention policy. This is a minimum of 6 years post matter close, consistent with the Limitation Act 1980. AI generated outputs that are not incorporated into a client file shall be deleted within 30 days. Okay, perfect. Now, in section 4 addresses the legal professional privilege. This is the specific risk for law firms. Now, what this is, the provision is unique to legal practice and has no direct ISO 421 clause equivalent, but it is a critical SRA compliance requirement. As this is the legal track in terms of this 10 module series, we have to include this. All right. Even though it's not part of the 42001 clause, it's very important with regards to the SRA standard. Now, the upper tribunal has held the uploading a client's confidential document to an open access API to may waive legal professional privilege over that document. All right. The SOP AI management system data document shall include an explicit prohibition. Legally privileged documents, including client communications, counsel's opinions, and privileged litigation materials, shall not be submitted to any AI system where the vendor's terms of service permit use of AI inputs for the model's training or safety research. The SOP shall define how fee earners identify whether a document is privileged and the escalation path when in doubt. And that will be the AI risk owner's approval required before submission. Next, we have 5, which falls under the ISO IEC 42001 2023 edition clause 8.3 and the UK GDPR article 17, the right to erasure. Establish a data deletion procedure for matter close and subject access requests. Now, what this is that the SOP shall specify what happens to AI related data when a client matter is closed. The AI system owner shall confirm when the vendor, via the data processing agreement terms, whether a deletion request can be submitted for a data processed during the matter. Where the data processing agreements provides for deletion on request, the AI management system program lead shall submit a deletion request within 30 days of matter close. Where the vendor does not provide deletion capabilities, this shall be documented as a residual risk and reviewed at the next annual AI management system management review. Now, under the UK GDPR Article 17, individuals may request erasure of their personal data. If a client or data subject makes such a request, the deletion procedure under the data processing agreement is the operative mechanism, and if no data processing agreement exists, the firm has no mechanism to comply to this. And then finally, in 6, now this falls under clause 7.5 and ISO 82079-1, the 2012 edition. Document control block and fee earner communication requirement. All right. The SOP AI management system data document shall carry the full AI management system document control block. This is the document ID, the version ID, issue date, approver, classification, retention, review trigger, or following any AI related data incident or AI system deployment. Finally, we have 6, which is the document control block and fee earner communication requirement. Now, the SOP AI management system data document shall carry the full AI management system document control block. This includes the document ID, the version, the issue date, the approver, the classification, the retention, also the review trigger. Now, this SOP shall be communicated to all fee earners who use any of the three in-scope AI systems. Communication shall be documented, a signed acknowledgement record, or a time-stamped email trail constitutes evidence of communication. Now, under ISO 9001, 2015, clause 7.3, awareness of the policy is not significant. Documented evidence of communication is required. So there has to be evidence that this information that has been documented has been made aware to all members of staff. Undocumented communication is, for audit purposes, communication that did not occur. Let's go to section 3. We're looking at the life cycle management. When an AI vendor updates its model, what does Halstead & Co. do? All right. Now, for ISO IEC 42001 clause 8.2, what it requires is organizations to manage AI systems throughout its whole life cycle. And this is from the decision to acquire them through to their retirement. So why does it matter if an actual AI vendor changes its model? Well, let's touch upon that. See, when an AI provider updates the underlying model, even a minor version increment, the system's behavior can change materially. The tone may shift, citation pattern may change, the model's handling of ambiguous legal questions may produce different outputs. Now, for a law firm where the output of the AI system is used in client advice, a single model change is a single change to the quality of that advice. Now, under ITIL 4, change in enablement practice defines a change as the addition, modification, or removal of anything that could have an effect on IT services. Now, an AI model update is a change under this definition. It requires documentation, assessment, and controlled implementation, not automatic acceptance. Clause 8.2 of ISO 2001, the 2023 edition, is this as a management system requirement and not just a technology preference. Now, let's look at the stages of the life cycle. And the stages, there is 5 stages. Let's look at stage 1. Stage 1 is the collection and procurement. So a risk assessment and a supplier assessment shall be completed before any new AI system is approved. The AI system register shall be uploaded before first use. That's stage 1. Stage 2 is the deployment. The testing criteria shall be documented. Model version shall be pinned. The data processing agreement shall be executed. And the COLP shall provide written approval before production use. Now we've got stage 3, and this is operation. Model version monitored for vendor initiated changes. Performance reviewed quarterly. Incidents are logged per the AI management system incident documentation, as well as the human in the loop procedure is enforced. Stage 4, we have change management. Now, model version updates shall be assessed before adoption. Prompt changes shall follow the PROC AI management system prompt documentation. Significant changes require the COLP, which is PRIA's sign off. Then the final stage is decommission. Data deletion request submitted to vendor. AI system removed from the Reg AI management system register document with a retirement date, and audit trail retained for 7 years. Okay, let's look at stage 4 in more detail, right? How does Halstead & Co. manage model version changes? In stage 4, you got the change management. This is the most frequently encountered in practice. For example, and other commercial AI providers update their models on a continuous basis. Now, without a documented procedure, every update is an uncontrolled change to a system the firm relies on for client-facing outputs. Now, the SOP management system lifecycle shall specify the following procedures for model version changes. Okay, and we've got 4 of them. All right, the first falls in line with ITIL 4, change implement clause. Oh, and also the ISO 42001/2023 clause 8.2. Now, the AI system owner shall immediately update all API call configurations to specify the model version string explicitly. Okay, what that means is that when it comes to a specific model that has been agreed upon, the API is configured to only use that model, regardless of whatever new models that come in. From the date of pinning, any change to a model version is a deliberate decision, not an automatic update. The pinned version shall be recorded in the Reg AI management system, the lifecycle, documentation, with the date of pinning documented. Okay. First, a model is decided on, and the API is configured to only use that model, regardless of any new models that Anthropic releases, so that any decision to use a newer model has been agreed upon internally and is updated the necessary documentation. Okay, the next one falls in line with clause 8.2 as well as ISO 9001, which is change control. So access every proposed model version change before implementation. Now, when an AI system owner identifies that a newer model version is available, or when the current pinned version is depreciated by the vendor, a model change assessment shall be completed before the API configuration is updated. The assessment shall cover A, what the vendor has documented about behavioral changes in the new version, B, a sample test comparing outputs from the current and the proposed new version on at least 5 representation manner types, C, the AI risk owner's written approval if any material output quality difference is observed. The assessment shall be documented with a reference ID format. And I've got an example here. And then filed in the AI management system document control register. Okay. Next, we have the prompt version control. So apply version control to all AI prompts, including the word macro instructions. The AI management system program lead shall extract all prompt instructions currently embedded in word macros and store them in a version controlled repository. This may be a Git repository, a SharePoint document library with version history enabled, or a structured folder on the firm's documented management system, provided version history is retained and recoverable. Now, each prompt version shall carry a unique version identifier, the date it was introduced, the name of the person who approved it, and a description of what changed from the previous version. The prompt, in effect, at any given time shall be deterministic if a client matters generate an AI output on a given date. It shall be possible to identify exactly which prompt version was used. In summary, there'll be a library of prompts which would have been approved and is available for all fee earners. They can't use any other prompts. And when it comes to newer versions of the prompts, as well as it being approved, has to have a unique version identifier, the date it was introduced to the business, as well as the person who approves it if it does get approved, and a description of what's different between this new prompt and the previous prompt. Okay, let's move on to 4, which for the 42001/2023 version clause 8.2, as well as clause 10.1, treat model depreciation notices as critical change events. Okay, so AI providers issue advance notices when a model version is to be depreciated. This notice shall be monitored by all AI system owner and treated as a triggered change event under stage 4, which is change management, of course. The AI system owner shall notify the AI management system program lead and the AI risk owner within 24 hours of receiving the depreciation notice, initiate a model change assessment, which is again step 2 that we've just covered, within 5 working days, and then complete the change and update the reg AI management system lifecycle documentation before the depreciation date. Now, failure to complete the change before the depreciation date may result in API call failures, of course. Now, a service disruption that affects the firm's ability to use AI system for active matters, this is an operational risk, not a governance concern per se. Okay, so let's quickly just look at the how does ITIL4 connect to this? So the ITIL4 connection, change, implement, applied to AI. So ITIL4's change, implement, practice defines 3 change types by risk and frequency. So standard changes are pre-approved, low risk, and well understood. Now, prompt wording adjustment that does not change the output category qualifies. Normal changes require assessment and approval before implementation. Now, a model version upgrade is a normal change. Emergency changes are implemented with minimum procedure due to urgency. A critical model bug fix requiring immediate rollback is an emergency change, for example. Now, when it comes to the SO AI management system lifecycle document, it shall adopt this classification explicitly. The classification of each AI change type determines the level of documentation required, the approval authority, and the speed at which the change can be implemented. This provides proportionality without sacrificing the ability. Okay, perfect. So let's go to section 4. We've got the AI vendor is part of your risk profile, whether you have a contract with them or not. Okay, now what do we mean by that? All right, the ISO IEC 42001 clause 8.4 requires the organization to determine and implement appropriate controls for externally provided AI systems or components that could affect the AI management system. Now, with the scenario, we've got Helsted & Co. Now, for them, this means formally assessing and contracting with every AI vendor before client data enters their system. Currently, this has not happened for any of the 3 in scope systems. Okay, now, what is supply chain governance? Now, supply chain governance under the ISO IEC 42001 clause 8.4 has 3 components for Helsted & Co. Now, the first is the supplier assessment. All right, so before new AI system is deployed, the vendor's data processing terms, security posture, as well as the UK GDPR compliance position shall be formally assessed. Now, second, the contractual controls. Now, a data processing agreement shall be executed with every vendor whose system receives personal data, specifically the purposes for which data may be processed and prohibiting use for model training without consent. Third, you've got ongoing review. So the supplier register shall be reviewed annually and whenever the vendor materially changes in terms of service. Now, an AI vendor that changes its terms to permit training on API inputs without notice has materially changed the risk profile of the firm's data submitted through that vendor's API. So there's 3 key steps there when it comes to clause 8.4. So you've got the supplier. You've got to understand what's their governance stance, UK GDPR, etc. You've got the second part of it, and that is the data processing agreement. There has to be an agreement, contract, to state that the information that we put into their AI models is not going to be used or stored for training their AI models. Okay, ongoing review. So as part of the governance, the documentation will always be reviewed annually. Also, whenever there is a change with the vendor when it comes to their terms of service. So those are the 3 key things here. Okay, so Next, let's look at the Helsted and Co. AI Supply Register. Okay, so this is the Reg AI Management System S. In this scenario, Helsted and Co. is using Quick, and as you can see here, there is action that is needed. So currently, Anthropic, their headquarters is in the US. Their service is obviously up in the US. Now, when it comes to the data processing agreement, is it available? Yes, it is. So Anthropic business API terms include a data processing addendum. The firm must be contracted on the business API tier for their DPA terms to apply. And the consumer API does not carry GDPR compliant DPA terms. Now you've got the transfer mechanism. So the UK addendum to the EU standard contractual clauses available via Anthropic's DPA, firms must execute this. It is not an automatic on API sign up. Now, when it comes to using the information to train their AI models, Anthropic's business API terms confirm that API inputs are not used to train their models by default. This must be confirmed in the executed data processing agreement. The consumer tier default differs. All right, so it only applies to the business tier. And then you've got the required action. So Helsted & Co. has to confirm that it's contracted on the business API tier and then execute the data processing agreement, including the UK addendum to the standard contractual clauses, and then file this information in the necessary documentation, which is the lifecycle documentation. And when it comes to the deadline, it's 30 days from module 4 completion. So 30 days from completing this module, these actions need to be actually fulfilled. So confirm that you're on the business tier and then execute the data processing agreement with Anthropic, which also includes the UK addendum. Let's look at the next supplier. So the next supplier is an unknown vendor. So because it's an unknown vendor, have no idea where their headquarters are. We're not sure where their location is. I'll say Helsted and Co. don't know where their location is. So it could be near UK, EU, US, or even China. No one knows. Now, when it comes to the data processing agreement, if you don't know who the vendor is, that can't be determined. So there is no in place. Now, this constitutes as a breach to the UK GDPR Article 28. Now, the use of the data being used to train the model, again, unknown because you don't know who the vendor is. So the actions that's required for this particular vendor. The lifecycle documentation is suspended for personal data processing per the instructions lifecycle documentation. Now, the corporate team lead to identify vendor within 14 days. So you have to establish who this vendor is. You've got the CLP assessment of vendor upon identification. So the moment the corporate team lead identifies who the vendor is, there has to be an assessment done straight away by the CLP, and then a data processing agreement executed or permanent discontinuation by 30 days of the deadline. File the vendor assessment as you've got the supplier assessment lifecycle documentation. All right, so this is an immediate action. Identify who they are. You've got 2 weeks to do that. The moment you identify who they are, the CLP, in terms of the scenario, that is Priya, we'll do an immediate assessment. And then based on that assessment, you would either execute the data processing agreement or you'll disconnect from that supplier totally, but all that has to be done within 30 days. All right. Now you've got the third supplier. The third supplier is internal. It's the word macro prompts. So you have the vendor status. So there's no external vendor if this is purely internal, as in local, in-house. All right. However, the macro's API call destination must be confirmed. Now, if the macro calls on an external LLM endpoint, that provider is an undocumented supplier. So the required action is for the AI management system program lead shall inspect the macro code to confirm their inference endpoint. If it is external, add the provider to the Reg AI management system supplier documentation and initiate the supplier assessment. If it's purely local, as in you've got a local model in-house, like an open weight model, Olama or something like that, for example, then document as confirmed and close risk zero in the Reg AI management system risk documentation. All right. So just to quickly summarize this one, if it's something like Copilot, then you've got to identify that the endpoint, the API endpoint, is going out externally to OpenAI, and then you've got to initiate the assessment. And if Halstead and Co has got a local in-house model, then that needs to be documented in the Reg AI management system risk document. Okay, so what is the ongoing obligations? The ongoing obligations is annual supplier reviews. All right. So you have a annual, so each year for the AI management system establishment date, all entries are reviewed in the AI management system suppliers documentation, confirm the data processing agreements are current, reassess vendor security posture, and update risk scores in the Reg AI management system risk documentation, where vendor's position has changed. Now, the owner of this actual review would be the AI management system program lead, and this falls in line with the ISO clause, ISO 42001, clause 8.4, as well as clause 9.3. Now, when it comes to the vendor change, what's required is assess impact to the terms of service change on data processing basis. So training use is prohibited and transfer mechanism. If the change removes protections previously relied upon, suspend use and notify the CLP within 24 hours. Now, it is the AI system owner who is the owner of this per system. This falls in line with the ISO clause 8.4 and clause 6.1. Now you have the AI system proposed for deployment. The action required here is to complete supplier assessment for new vendors before any personal data is submitted. The assessment shall follow the template in the SOP, AI Management System Lifecycle Documentation, Stage 1. The data processing agreement must be executed before production deployment. Now, the owner of this action is the AI Management System Program Lead, as well as the COLP. This falls in line with ISO Clause 8.4, as well as Clause 8.2. Finally, you have the AI-related data incident involving vendor. Now, the action here is initiate incident procedure, and that's the PROC AI Management System Incident Documentation. We'll go into that in Module 5, the next module. Now, assess whether the incident constitutes a UK GDPR personal data breach, requiring ICO notification within 72 hours under the DT18 Section 67. Now, the owner of that is the CLP. In this case, in this scenario, that's PRIA, and that will fall in line with the ISO clause 10.1, as well as the UK GDPR Article 33. Now, there is a correct way to exit a vendor, so an exit strategy. Now, when it comes to the Reg AI Management System supplier documentation, it includes a vendor exit strategy for each supplier. So the exit strategy does not need to be immediately executable. It just needs to be documented. So, for example, for Anthropic, identify an alternative commercial LLM provider with comparable capabilities and GDPR compliant data processing terms. Document the prompt migration steps, estimate the time to switch, and then for the vendor, once identified, make sure that they're documented. So document the contractual exit provisions and data deletion process. Now for Anthropic, as the current vendor, document the contractual exit provisions and data deletion process. A firm with a documented exit strategy is a firm that has genuinely assessed its AI supplier dependencies, and that assessment itself evidence of governance maturity that a SR will recognize. Okay, so we've got section 5. We're looking at the client disclosure. All right, so transparency. Now, for ISO IEC 42001 Annex A, and that's Control A.2. It requires organizations to implement appropriate transparency measures for AI systems. Now, the SRA's compliance tip, updated on the 9th of February 2026, state explicitly it should always be made clear to clients where they are interfacing with AI. So with Halstead & Co., no AI assistant correspondence or document has ever carried this disclosure. Every output the firm has produced for the clients in the last 8 months of them using this AI tool has been sent without it. All right. So that's Halstead & Co.'s current, in this scenario, current position. Now, this is not a future obligation. This is a current one. All right. So the SRA Code of Conduct for Firms 2019, Rule 7.1, requires firms to give clients information in a way that they can understand and in a manner that meets their needs. The SRA's February 26 AI guidance makes the transparency requirement explicit. Neither provision has a future commence date. They apply right now. When the dispute resolution team at Halstead & Co. sends a client a research summary produced by Anthropic, for example, without disclosing that AI was used, the firm is in breach of both the SRA Code of Conduct Rule 7.1 as well as the SRA's own AI guidance, which they released in February 2026. Now, this has been the case for every AI assistant output the firm, i.e. Halstead & Co. in this scenario, has produced since it began using the commercial LLM. The disclosure document produced in this section remedies this from the date of issue. It does not remedy what has already been sent. Now, in case of Priya, the COLP, she should consider whether she should go and disclose to the clients who's actually acted on the material that's already been submitted that was created by AI, to let them know that that information that we've given you and you've acted upon was generated by AI, and in the future we will let any information that we do submit or give you, whether it's done by AI or not. Now, that's a choice that the firm and the COLP has to make. Now, what does the disclosure contain? Now, there's 6 mandatory elements of what a disclosure should contain. All right, so the AI management system disclosure documentation shall define 2 disclosure formats. Type A, inline disclosure, which is a short statement embedded in AI assistant correspondence or documents, appearing prominently near the top of the document, used for letters, research, summaries, contract review outputs, or any document where AI was used to draft, summarize, or analyze. Then you have Type B. Now, Type B is client engagement disclosure. Now, what that is a paragraph in the firm's client care letter and terms of engagement, or informing clients at the outset of the matter that the firm uses AI tools and explaining the human oversight process. So the human in the loop element. This proactive disclosure satisfies the transparency obligations and avoids repeated inline disclosures on every document, provided the client has been informed at matter inception. Now, when it comes to Halstead & Co., they shall implement both types. So Type B shall be added at the care letter template immediately upon issuing the AI management system disclosure document. And let's look at some examples of that. So I've got here the Type A inline disclosure template. And as you can see here, we've got the AI systems used. So this will be the name of the AI system, the nature of the AI assistant. So defining what is the tool used for, whether it's research summary, document analysis, and so on. Then you've got the human review performed by. So this is the human in the loop element, and it got their name and their role, as well as the reviewed date and approval date. You've also got the verification step. So all legal references, citations, statutory provisions has been verified against primary sources by the reviewing solicitor prior to the issue. All right. And then you've got the AI policy reference. So this document was produced in accordance with the Helsted and Co.'s AI policy, which was covered in Module 2. And a copy of that policy is available upon request. So that is a template of what the inline disclosure looks like. Now, when it comes to the client engagement disclosure, you've got the disclosure statement. So this is things for client care letters. So you've got the client disclosure statement. So here's an example here where it's got Helsted and Co. LLP uses AI assistant tools in the delivery of legal services. These tools may be used to assist with drafting, legal research, and document analysis. All AI assisted work is reviewed and approved by a qualified solicitor before issue. AI tools are never used autonomously to provide legal advice without human review. So that's one client information notice. The next one is the client's rights. So as a client, you may at any time request that AI tools are not used in handling of your matter. Please identify your supervising solicitor if you have any concerns about the use of AI in your matter. This will not affect the quality or the prioritization of the legal services provided to you. So that is the client's rights. And then you've got the data protection for the client. So your matter information may be processed by AI tools operated by third-party providers. These providers are subject to contractual data processing terms that prohibit use of your data for model training. Further information is available via our privacy notice as well as the AI policy, copies of which are available upon request. Now, again, these are just template examples. The target audience for this are qualified solicitors, CLPs, etc. You know how to word this appropriately, but this is just me putting examples of what would be the tone, the language that would be used in this client engagement disclosure, for example. All right, so we've got the type A and the type B. Let's look at how we go and implement the steps to produce this document, this AI management system disclosure document. All right, so the implementation steps fall in line with the relevant standards, which we'll go through. So the first step falls in line with the Annex A.2 as well as the SRA Code of Conduct Rule 7.1. So that is to issue the disclosure document and update the client care letter template immediately. So the client care template, which we just looked at here, we've got to update quotations or letter templates to include that. So the type B disclosure shall be added to the client care letter template used by all practice groups within 5 working days of this module being completed. The update template shall be version controlled in the firm's document management system. The AI management system program lead shall notify all fee earners of the update and confirm that the new template is in use. For any active matter where the client care letter was issued before the disclosure was added, the supervising solicitor shall assess whether a supplementary disclosure letter to the client is appropriate, particularly for matters where AI assisted work has been delivered. Okay, now step 2, which falls in line with, again, Annex A.2, but this time the ISO 9001 clause 7.3. And this is to train all fee earners on when and how to apply type A inline disclosure. And as a quick reminder, let's just go up. Type A, we've got the AI assisted disclosure, which we covered here. The type A disclosure shall be applied to every document or correspondence where AI assistance was used in drafting, summarization, or analysis. All right, the AI assistance. This includes any use of Anthropic, whether it is the Copilot or even that Leap AI, okay, to produce text or analysis to include in the output sent to the client. It does not include using AI tools solely for internal research that is not reflected in the client-facing document. The distinction matters. It requires fee earners' judgment, which requires training. The AI Management System Program Lead shall deliver a 30-minute training session covering when the disclosure applies, how to complete it, and why it matters. This has to be done within 15 working days of the disclosure document being issued. And attendance is mandatory and recorded. All right, so implementation step 3 falls in line with the 42,001/2023 clause 9.1 and the Annex A.2, which is the performance monitoring. So monitor compliance with the disclosure requirement as an AI management system performance metrics. So when it comes to the clause 9.1 of the ISO IEC 42,001/2023 requires the organization to monitor, measure, analyze, and evaluate a AI system performance. The disclosure compliance rate is an AI governance metrics. So what percentage of AI assistant documents sent to clients in a given quarter carried the type A disclosure? The AI risk owner, which is Priya in this scenario, shall include this metric in the quarterly AI management system performance review from the date of the disclosure document being issued. 100% compliance target is appropriate. That is the goal. Anything less than that is a failure. The SRA's obligation does not permit partial compliance. So again, 100% is the only thing that's acceptable. If any AI assisted document is identified to have been sent without the required disclosure, this shall be logged as an AI management system non-conformance under clause 10.1 and assessed for whether client notification is required. So those are the 3 major implementation steps. Now again, I have a template here, and as you can see with the template, it's got all the relevant sections that we've talked about. It's got the disclosure questionnaire. For an example, we've got list an AI tool, application or AI enabled feature your team uses in legal work. I've got some examples here, and you'll just put in your answer. We've got an AI system inventory. I have got some examples already in here. So you will have your different AI tools. You will list the vendor, the model version, so what models you're actually using within the tools, if you know them, what's their intended use, the data categories, the risk, and the oversight mechanism. So the documentation also includes the prompt version log. So again, you've got the version, the date, the author, who is it approved by, the change description, and then the reference to the prompt. This also includes the register maintenance procedure, giving you the deadlines. For example, you've got existing system version change. This needs to be done within 5 working days, and so on. So you've got here the actual procedure and deadlines for what actions are required based on the trigger events. And then finally, with the section 5, I've got here the version control and communication logs. This is a template that you could download and tweak and make changes as you wish. This is just a template to give you an understanding of the different sections and the key elements of what the sections include to fall in line with what we've just covered here. Now, in the link below, you'll be able to download this as well as get access to this module. The module also includes the checklist. So as you're working through the module, you could tick off as well as your understanding of the different sections that we've covered, which was the data flows, the data governance, the management, the supply chain, and the client disclosure. So as you're working through that and implementing it throughout your firm, you could use this as a nice checklist to make sure that you are on track. Okay. Next, we're going to be talking about module 5, and this is the human oversight. So the human in the loop, as well as the incident management. How do we deal with reviewing AI outputs, and what happens if an AI output has slipped through the net with wrong information, for example? Okay, so module 5 will build the controls that operate every day a fee earner uses an AI tool. The human in the loop procedure which defines exactly how a fee earner reviews, approves, and sign off an AI assisted output before it reaches a client. Closing risk 1 and risk 2 from the AI management risk document. Now, module 5 also builds the incident procedure, the AI incident procedure documentation. And this is what Halstead and Co does when the AI produces, a fabricated citation, sends incorrect advice to a client, or triggers a potential GDPR breach requiring the ICO notification. By the end of module 5, Halstead and Co will have a fully operational governance framework, one that could withstand a SRA thematic review visit. So until then, look after yourselves, and I will see you in module 5.